Matter of the People, State of Michigan versus Keith Williams. This is file number 2025-24-37-21-FY. Mr. Williams, it's charged that you were fleeing and eluding a police officer to whom was given a visual audible signal by voice and emergency light or siren. Police officer was in full uniform and the officer's vehicle is identified as official police vehicle acting in lawful form of his duty, directing you to bring your motor vehicle to a stop, did willfully fail to obey such direction by attempting to flee or elude the officer, and a violation resulted in the death of another person. You understand that charge? Fleeing and eluding first degree is punishable up to 15 years in prison and a fine of up to $15,000. Your driver's license will be revoked for a period of not less than 5 years. Do you understand that? You're also charged with reckless driving causing death. Do you understand that charge? That is a felony. It's punishable up to 15 years in prison and or a minimum fine of $2,500, max fine of $10,000 plus court costs. You understand that? And your vehicle will be immobilized unless it's forfeited. And you're also to reimburse the government for emergency response and expenses for prosecuting you. Do you understand that? You're being charged as a second felony offender because of a prior conviction of resisting obstructing a police officer here in the 14th Circuit Court. If you're convicted as being a second felony offender, each of these offenses will be punished by up to 22 and a half years in prison. Do you understand that? Okay. You have the right to the assistance of an attorney, if you cannot afford an attorney, one will be appointed for you. Do you understand that? Do you wish to have an attorney? Can you afford an attorney? Okay. Okay, I have some papers here. I'll send this over to the defender's office for them to make an appointment.
Your Honor, I was able to speak to Mr. Williams this morning, so we will be entering an appearance on this case.
Okay, very well. You have a right to remain silent. Anything you say orally or in writing can be used against you in court. If you cannot afford an attorney during question, the court will appoint an attorney for you. Do you understand that? And you have a right to have a preliminary examination. I'm going to schedule this for a probable cause conference a week from tomorrow, August 3rd, August 7th at 1:30 in the afternoon. The preliminary examination will be the following Thursday, August 14th at 10 o'clock in the morning, and that'll be in front of Judge Kostrava. The final matter before the court is the question of bond. Mr. Roberts, is there anything you'd like to say on behalf of the prosecution?
Yes, Your Honor, thank you. The people are requesting a $500,000 bond at this time. As the court is well aware of the factors under MCR 6.106 subsection F to look at, a number of those factors do weigh in favor of setting a significant cash bond on this case. First, as the court has already indicated in reading the information here, Mr. Williams does have a prior conviction for resisting and obstructing a police officer. He was in fact on probation for that offense when this took place and is actually facing a probation violation and had a probation violation at the time this incident took place. He has since subsequently
Already had a probation violation.
Already a probation violation pending, and that warrant had been outstanding for a period of time and he had not answered that warrant. So that is a factor that weighs in favor of a cash bond. Secondly, the record of non-appearance here, the fact that he has not answered that warrant, and the fact that that incident did involve also attempting to get away from a police officer, and this incident also involved attempting to get away from a police officer. It indicates that Mr. Williams does not have a regard for following the orders that are given to him to comply, whether that be through the court or by a police officer. The seriousness of the offense here almost speaks for itself. Obviously, this is a case that involved the tragic death of a citizen here. This took place in the middle of the afternoon on one of the busiest streets in Muskegon. It's certainly one of the busiest times during the lunch hour. Traffic on Lakeshore Avenue, which is a very populated avenue around several residential neighborhoods. Mr. Williams was attempting to get away from a police officer who had turned around on Mr. Williams to conduct a traffic stop, and very quickly recognized that Mr. Williams was not going to stop, and because of the danger to the public posed by that, the officer terminated his pursuit.
Well, it's my
Nevertheless-
understanding he crashed into another vehicle and the officer stopped to assist the vehicle that was damaged and terminated the
Yes,
pursuit.
terminated his pursuit pursuant to policy there, recognizing that there was a danger and that his continued pursuit might pose a danger, so relayed that information to other officers. Mr. Williams, still in an attempt to get away from the police, not just that officer, but any other officers involved, continued down Lakeshore at speeds that may be in excess of 75 miles per hour down essentially a two-lane road, hitting and swerving around other vehicles until he tragically struck and killed the motorcyclist that was involved here. So obviously the seriousness of the offense here, I think, weighs heavily in favor of cash bond. This is not a case at this point for which he could be held without bond, but certainly it does approach that seriousness. In addition, the likelihood of a conviction here is obviously another factor for the court to look at. Mr. Williams acknowledged to the police in his statement to the police that he did see the police officer, saw him turn around, saw him turn his lights on, and was attempting to get away from the officer when this incident took place. So I'd say there is a high likelihood of conviction here, certainly on the fleeing and eluding charge. And the reckless driving, the nature of it just really speaks for itself. Although not specifically a factor, I would also indicate to the court that we are exploring some potential additional charges against Mr. Williams that would result in an additional charge of perhaps operating while intoxicated, causing death. We are waiting for toxicology results. That blood obviously will take some time to be analyzed by the lab, but certainly depending on the outcome of those, there could be an additional charge forthcoming for that offense as well. So for all those reasons, as I've indicated, the court, I believe, is fully justified in setting a significant cash or surety bond for Mr. Williams for the seriousness of the offense, the likelihood of conviction, and Mr. Williams' prior record.
Okay.
We request the court utilize a lower cash bond. I recognize the serious nature of this alleged offense, but these are all still just allegations. Mr. Williams himself is a lifelong resident of the Muskegon area. We can look at his criminal history. He only has 2 entries. And neither of these are truly assaultive in nature, at least not assaultive towards another person. I don't know the specifics of his R&O case, but he's not an aggressive person in terms of assaultive nature. We would just request the court use a reasonably lower bond.
Okay. Mr. Roberts, it's my understanding he was involved in one crash and he continued on, involved in another crash, his vehicle was rolled over, and then he ran away from that and was found under a bridge.
Yes, that's correct. He was attempting to get away from the vehicle that after the crash in which the motorcyclist was struck and killed, that vehicle then rolled down the embankment, and Mr. Williams fled from that vehicle and had to be pursued essentially on foot by police officers, where he was subsequently arrested away from the vehicle.
Mr. Williams, is there anything further that you wish to say before I set the bond?
Mr. Williams, I would strongly advise you not to say anything else.
I think that the $500,000 cash assured bond request is appropriate, and so I'm going to set the bond amount at $500,000 cash assured. You'll have to put up $500,000, or by a surety bond will cost you $50,000. You have to promise to keep the court notified of your address, show up on time for all hearings you've been notified of, not leave the state of Michigan without the court's permission, not commit any crime, blood, and bond, not to consume any alcohol or drugs unless prescribed by a physician, no marijuana, and unless prescribed, and you just submit to testing as directed by the court. We'll schedule this for a preliminary examination, a probable cause conference a week from tomorrow at 1:30, preliminary examination the following Thursday, 10 o'clock in the morning. Do you have any other questions? Okay, you're all set.